the police commissioner asking a security guard if he wants to be shot doesn't rise to the level of disturbing the peace, what does? KSPN takes a look. Under CNMI law, disturbing the peace is defined as unlawfully and willfully doing any act that unreasonably annoys or disturbs another person to deprive him of his right to peace and quiet. Last February, a security guard, Rudy Miraflor, filed a disturbing the peace complaint against DPS Commissioner Ray Mafnas after Mafnas allegedly harassed him at his post at Suicide Cliff and asked him if he wanted to be handcuffed and shot. Miraflor said Mafnas shouted at him and even flashed handcuffs, and he told KSPN and police that he was afraid for his life. The incident was documented in an internal report to Miraflor's supervisor and also in a police report. But Miraflor's complaint won't be prosecuted because the Attorney General's office says Mafnas didn't break the law. According to the AG's report to the governor released this week, asking a security guard if he wants to be shot borders on being a law violation, but isn't because the so-called offer was posed as a question, and there was no allegation that the commissioner's firearm was visible. One private attorney, David Bain, says he's seen people prosecuted for much less in the CNMI, and while he thinks it is a close call whether Mafnas' conduct constitutes disturbing the peace, he also thinks the AG should have done more to investigate.
As I understood it, that the commissioner said he didn't have a gun. Instead, it's just that the security guard couldn't see a gun. So there could have been a gun involved. And that's troubling. And it's troubling to have a commissioner saying, as I understand it, or any police officer saying, do you want me to handcuff and shoot you?
According to Baines, the AG's office failed to ask certain critical questions.
As I understand it, the security guard was never asked if his peace was disturbed or if he felt scared. And if he wasn't asked those questions, and if the commissioner wasn't asked if he had a gun, the question is, why weren't those questions asked? And the whole reason that we're asking these questions is because we don't have confidence in the independence of the Attorney General's office.
So what disturbing the peace complaints is the AG prosecuting? Earlier this month, KSPN reported that high school student Robert Narita was arrested at school during exam week and held in prison for 7 days after being accused of yelling and swearing at his mother. On April 2nd, the AG's office filed one charge of disturbing the peace against him, and we've since learned that another charge was filed for an earlier but similar incident between the teenager and his mother. According to the mother's statement to police, after she slapped her son's mouth, he asked her, "Do you want me to hit you?" Nothing in the allegation says the teenager actually hit his mother, however, nor was any weapon involved. The mother wrote that she was disturbed her son called her names and disobeyed her. The AG's office brought criminal charges against Narita the same week that Commissioner Mafnas was interviewed.
Thanks, Tina. Jeanette Roche reporting. We return to the question then, how can a statement about shooting someone be classified as an offer rather than a threat? We speak to Attorney General Ed Buckingham to find out how he came to the conclusion in the Ray Mafnas investigation.
We were looking at whether or not this was a violation of law. In this case, it was presented as a question. It was not accompanied by any gun. There was no gun observed in possession, no gun used as a threat. If we change the facts with a person with a sidearm saying, "Do you want me to shoot you?" No question. That would be a violation of law. That isn't what the facts showed.
The AG says his office reviewed police reports and interviewed the individual who complained.
We did not in any way say that statement was appropriate.
But Buckingham says they took the complaint very seriously.
We had a continuum of least to most important. This was the second highest rating on our scale. Now, I understand people can say, gee, you should call that a law violation. Well, we looked at this through the eyes of, if this was a case, would this be a case that based on what we saw we would prosecute? And the answer is no.